Hello, and welcome to our video series about the ins and outs of probate court. I'm Edward Littlejohn, and I'm here with attorney Jeffrey Minoski to discuss the ins and outs of probate court with you. This webinar is for anyone who is a executor, anyone who has lost a loved one, or anyone who's not named an executor that is looking for trusted legal advice and guidance regarding the probate process. This is also for any sole heirs or surviving spouses who, again, are looking for guidance to navigate the probate process. This is not for any siblings that are combating over the probate process, but more this is an overview of the probate process for anyone who's looking for guidance and just the basic understanding of the probate process. Jeff, you want to tell us a little bit about yourself?
Sure, Edward. I've been working with you here since about 2016.
Yeah.
I do a lot of real estate litigation, and the rest of what I do is mostly probate and estate administration.
Yeah.
Really enjoy that side of it too.
That's right. And the probate and estate team, so we have a probate and estate planning team here at Littlejohn Law. They focus on the estate planning aspect, but also the probating and navigating through the probate process. Now, Jeff, whenever we sit down with a new probate or probate administration client, one of our main focuses is on minimizing the probate court's authority. So what we try to do is kind of make sure that, would you say we make sure their assets aren't in probate, or talk the viewers through this, Jeff?
Okay, well, in a typical estate planning situation, we try to set up our clients in the best way possible so they can avoid probate court. And when we sit down for a probate administration meeting, the first thing we look for is insurance policies, any type of retirement account that would have a named beneficiary, anything that we could, send a letter to and collect on, right off the bat before having any involvement from the court. That's great,
Jeff.
I guess I would classify that as non-probate assets.
Right, and I was going to say
identify them on the front end.
Right, and so before we dive too deep in this, we make a distinction early on between probate and non-probate assets.
Right.
And probate assets, would you say that those are assets that are solely in the deceased or your loved one who passed away's name?
Yes.
Okay. And so we look at those assets as probate assets, and we know the only way for those assets to transfer is by way of the probate court.
Correct.
At the same time, you said we look at the non-probate assets. Those are the life insurance policies. Sometimes they're real estate, maybe bank accounts that we can transfer outside of doing a full administration or release of administration.
Right.
Okay, that's great. The one thing that you kind of touched on that I want to make sure that everybody understands is, what is the purpose of the probate court?
The purpose of the probate court is to kind of oversee the administration of the estate. Basically, any type of probate asset that the deceased person would need to sign off on to transfer, that's what the probate court helps us out with.
Okay. So just basically any assets, right?
Right. Any assets that are solely in their name that they're not here to sign over.
Okay. And so one of the most common questions that we get when someone passes away is, what do I do first, right?
Right.
Do I go get death certificates? What do I do?
And the first thing to do would be to contact the funeral home of your choice. Depending on the funeral home, I know a lot of them will handle the death certificates for you. They will notify Social Security for you. I mean, there's kind of like a preliminary list of 3 or 4 things that I think most funeral homes handle.
Right. And if you guys are looking for more information on the specifics, please download our Survivors Checklist, which gives you a step-by-step guide of all the people that the funeral home will notify. Like Jeff said, they will notify the county and get you a death certificate. They will also notify Social Security. You may need to notify a pension or a retirement plan. But some of the responsibilities are the responsibilities of an executor or an administrator, somebody who's going to handle the estate and kind of lead the probate process. In our team, we help out with that as well. Jeff, diving into, I guess, a little bit more about once we've identified the assets, right? So people have a bunch of assets, maybe their house, car, bank account. You've said we make a distinction between probate and non-probate assets. And then from there, normally the bills start piling in, right? If I'm an executor or even administrator or a loved one, am I responsible to pay for the bills?
No, not personally. But the only thing that I want to bring up, if the bill is for a secured asset, like a mortgage on a house or a car payment, bills like that do need to be paid by somebody if you care about keeping the asset.
Okay. So they have to be paid by somebody, right?
Right. Only those, like a car payment or a house payment. If it's like a credit card payment, medical bills, anything like that may come in, cable bill, things like that, they don't need to be paid.
And just so we're clear, if a house payment, there's a mortgage on the house.
Right.
There's a lien on the car, and I'm the executor, right? Am I responsible to pay for that out of my pocket, or is that something that comes out of the administration of the estate?
Oh, it comes out of the administration of the estate.
Okay.
But in order to get to that point, you would need to be appointed by the court, open up an estate account, at least get access to some money from a checking account.
Okay.
So that may take, depending on the circumstances, it may take a month or two to get to that point.
Right, and I just wanted to clarify for our viewers that they're not personally responsible to pay. Like if something would happen to a loved one of mine and I'm named the executor, I'm not personally responsible to pay for the mortgage on the house. I'm not personally responsible to pay for the loan on the car. That would be paid through the administration.
Right.
Okay. Getting back to something else that you touched on, we've now gathered all the bills, and you said before the bills can get paid, the probate court has to designate somebody as an administrator or an executor.
Right.
Yeah. And I guess the other little analysis piece to this would be what's the value of the estate, right? Because that's going to dictate what kind of avenue or vehicle we use once we get into the probate court.
Right.
So tell the viewers a little bit about the release of administration and some of its requirements versus a full administration and some of their requirements.
Okay. Well, with a release from administration, we basically file a packet of paperwork with the court, and the judge approves it, signs off on everything, usually within a week of us filing. If all the heirs sign all the releases and basically sign off on everything.
Right, and the packet of paper that you referred to are very specific probate documents.
Yes.
And we commonly see other attorneys make mistakes when they open up an estate that should be a release of administration, and they make a full administration. So they have some of the wrong forms that are filled out and submitted to the probate court.
For sure.
Okay. And so one of the important things is to properly identify the assets so that you can make either the release or the full administration, because that mistake, isn't that a critical mistake?
It is. It's possible to convert a release from administration into a full administration or vice versa, but it's just a lot more work and paperwork that it's much easier to get it right the first time.
Right. And then it may end up costing the estate because it's a different timeline. If we're looking at a release of administration, we could open and close an estate within 6 months, where a full administration, we're going to look at a minimum of 9 months to a year.
Right.
Okay. Are there any dollar figure amounts for release of administration?
There is. The magic number in Ohio is $35,000.
For a release of administration.
For a release.
And that number of 35,000 does not apply to surviving spouses. That applies to just general heirs. So is that correct?
Right. The surviving spouse would make the number 100,000.
Okay, so if a surviving spouse passes away, then that number is 100,000. But if it's not a surviving spouse, so maybe children or just like a cousin or somebody else,
right,
that number is 35,000 or less.
Right.
Okay, great. And so other states have different numbers for releases and full
Right.
administrations.
Right. Most states have some procedure for handling the smaller estate, but it's a little bit different than what we do here.
Right. And we practice in both Ohio, West Virginia, and Pennsylvania. So if you have a probate matter in any of those states, give us a call and we can get you on the pathway to success. But Jeff, moving forward through the probate process, the full administration. What is a full administration?
With a full administration, the court will actually appoint you as the executor if you're named that in the will, or they will appoint you as the administrator if there's no will. And what that's called is a letter testamentary. And that is basically the document from the court saying that you get to be the executor, you get to be the administrator, and that's the document that you will use to open up an estate account, to communicate with any creditors, to transfer assets. That's kind of the key to the whole thing, that one court document.
Right. The letters of, what did you call it? I'm sorry.
Letter testamentary.
Letter testamentary.
And once you have that, then you can really start hitting the ground and, transferring assets and doing the work.
Right. And just so we're clear, an executor, just because you're named an executor doesn't mean that you inherit more than anyone. If you're named an executor, your primary duty is to manage the affairs of the estate. And to be quite honest, you're in a position of authority, or as the court likes to call it, a fiduciary position, Jeff.
Right.
So there are additional responsibilities on you as a fiduciary, would you say? You want to touch on that a little bit?
Right. As a fiduciary, you have a duty to the estate, not to commingle funds like with your own checking account.
Right.
Not to mishandle assets or misallocate anything.
Right.
If you have an investment, you have a duty to try to, sell it at the right time or make sure it appreciates as much as possible.
Sure, and then even like a duty to buy homeowners insurance, keep
Right.
homeowners insurance on the house so that it doesn't decrease in value, or if a fire or something happened, that it would be covered.
Right.
So there are a lot of important things about the executor as a fiduciary. Jeff, I think we kind of skipped over it, but we jumped into the executor, and so I want to take a step back and just talk about the fact that somebody gets named an executor when we have a will. If there's no will, they're called an administrator. Now, if we open up a full administration with no will, tell us about that process. Is that very similar to the process you just laid out?
Yes, it's similar. Somebody will apply to be the administrator. The only caveat to that is if somebody else has an equal right to be the administrator, like a person passes away, they have 3 children, one child applies, the other 2 would have to sign off on that other person being the administrator.
Okay. And the other, I want to just make sure that everybody's aware, the other like hidden cost or hidden factor if someone passes away without a will is they may have to post a bond.
Correct.
Right. If you have an executor and a will, most wills say that bond is dispensed, but no will, you may have to post a bond. Tell us how the bond relates to an executor and their fiduciary duties.
The bond, the purpose of it is to protect the estate in case the executor breaches their fiduciary duties. Like if they, embezzle money or hide assets, something like that, the bond is there to protect the estate and the other beneficiaries.
Okay, so if the executor breaches their fiduciary duty, the bond would make sure that they're protected.
Right.
And so when there's a will and there's no bond, it's very important for the executor to pay attention to what's going on because there is no bond to protect them. Okay, great. After an executor or administrator gets appointed, and we're at the point where we've identified all the assets, we've also identified all or most of the bills. The next part is to file an inventory and appraisal.
Correct.
Right? The inventory and appraisal is just putting the probate court on notice as to what the assets are?
Essentially, that's it.
Okay.
There's a form that you fill out where you can put in what the asset is, what its value was on the date that the person passed away. Mm-hmm. If anything needs to be appraised, like jewelry or some household items, something like that, you can ask for an appraiser to be appointed. when you apply to be executor. But that's really all the inventory is.
Okay.
It states the gross value of the estate, and then there's an itemized list of what everything is and what it's worth.
And most of the time when we deal with discord or even some probate litigation, it arises at the time of the inventory and appraisal.
Right.
You want to touch on that a little bit, as what you can do if the executor leaves off an asset from the inventory and appraisal?
Sure. When the executor files the inventory, they have to have everyone sign a waiver of notice of a hearing. Hearing. And the way that works is that the probate court, it's not like a hearing in open court. They will probably just have the magistrate review the documents and sign off on them if nobody objects. But if the executor did leave something out or included something that you think shouldn't be in there, you're allowed to file what are called objections to the inventory. And then in that case, the court would not just sign off on everything. It would get set for a hearing in open court,
Okay.
where you would be able to present your evidence, ask the executor any questions that you have.
Okay. So the siblings or other heirs can contest the estate at the inventory and appraisal by filing written objections, which eventually get set for a hearing.
Right.
Okay. The other, I guess, interesting thing about this, Jeff, is when we look at probate litigation, that's probably the most highly contested piece, right? The inventory and appraisal. The other most common contested piece would be the will in and of itself. Right?
Sure.
Tell us about that. Like, what is a will contest? As the legal term is a will contest. What is that, Jeff?
A will contest is when someone believes maybe they should have been named in the will, or that there is another version of the person's will out there, and they will file a motion to admit, their version of the will into probate.
Yeah. Okay, and so basically the will contest is two different people fighting over different versions of the will.
Right.
Yeah.
It could be that, or it could be the will we have. They may be saying that the person was not competent to execute it, and that it should just not be considered.
And we've had experience with both of those situations.
We have.
One where the will was, I would say, non-existent, and someone put forth a handwritten will, and another one where somebody said that the decedent executed multiple wills, right? And was incompetent to answer or execute the other will. If you're able to get past the will contest, you're able to get past the inventory and appraisal objections. At some point in time, the probate court allows you to make distribution.
Right.
Tell us about this distribution process. If I'm named an executor, does that mean I get to take all the money and keep it myself?
No.
Okay.
No. You would open up an estate account and deposit it in there. And as far as making the distributions, we always recommend that no one makes a distribution until 6 months from the date that the person passed away.
Okay, and why would we want to wait 6 months, Jeff?
In Ohio, creditors only have 6 months to file a claim.
Okay.
And if they don't do it within the 6 months, they are just cut off.
And in addition to them only having 6 months to file the claim, isn't there a specific procedure that they must follow? And if they don't follow that specific procedure, then they lose their right.
Right. The Ohio Supreme Court has held that they have to make their claim directly to the executor, not filing it with the court, not serving it on the attorney, not sending it to a beneficiary. There's a specific way that it has to be served directly on the executor.
Okay. Well, Jeff, is there anything else about the distribution process that you want to let the viewers know today?
If you do make a distribution inside the 6 months, it's always a good idea to have the person that you're making the distribution to sign some sort of release saying that they will pay the money back if an unknown creditor would pop up or something would change. It's good to get their signature.
And then once all the distributions are made, you have to file a final inventory and accounting with the probate court.
Final accounting.
Okay.
And that's another stage where people could file some objections.
Okay.
That at that point they would be saying that we agree on we agree on the inventory, but we disagree with the way that you distributed.
Okay, great. The viewers, they have to be wondering, Jeff, attorney's fees. You know, I mean, it's something that comes up all the time when we have conversations.
Right.
You know, attorney's fees. So one of our approaches to the probate administration are to see if we can make it a release of administration.
Right.
Versus a full administration, because there's a lot more work involved in the full administration. But this is highly dependent on the types of assets, the assets, the debts, also how many creditors there are, but how many loved ones there are. Depending on the complexity dictates the process. But in general, there's three main ways that law firms get compensated. We have the flat fee model, the hourly retainer model, and then the percentage of the estate.
Mm-hmm.
So you want to talk a little bit about the flat fee, Jeff?
Sure. Usually we use a flat fee when it's a release of administration.
Yeah.
Just because there are not a lot of hours involved in that.
And I think it will be because of the certainty, right?
Right.
We know when we open it up, we know that if we meet these requirements, the case can open up and then be closed within a specific amount of time once we have all the documents.
Right.
Where the full administration, we normally use a retainer type
right.
model. And would you say that's because of the uncertainty? Or?
Right. It's because of the uncertainty and just all the additional papers we have to move.
Right. And I would say the additional papers, additional steps in the process. I know we were working on the estate, oh gosh, that was several months ago, Jeff. And you had to go all the way to the Pennsylvania Orphan Court. I
did.
You remember that. And the day you went, the court was actually, were they closed? Or tell the viewers about that a little bit, Jeff.
Oh. Which time? Because I had to go a couple times.
Well, I was thinking about the time when you had to get the emergency order to have the sale.
Oh, okay.
That's the time I was thinking of.
Okay.
Yeah.
What happened there is we had some real estate in the estate. And the executor hired a realtor. They found a buyer. They were ready to close. And a week before the closing, I got an email from the title company saying that we need an order from the court increasing the amount of bond.
Wow.
To handle the cash from the sale.
Yeah, and that estate in and of itself was complicated because our client is from Ohio, loved one passed away in Pennsylvania. Because they were out-of-state resident, client had to post the bond, and then it had to jump through all these additional hoops with the order of the sale. I mean, it was...
Right, and usually with bond, there's... usually it's a surviving spouse, or usually there's a will. You just usually don't have to post bond. Yeah. And that's the only time I've had to do that.
Wow. Yeah. I would say that was the only time that you had to do that. But our experience relating to bond is vast and somewhat deep, because it brings me up to reminds me of another estate where our client lived in, I think, North or South Carolina, and there was no will. They weren't the surviving spouse. They were just the sole heir. And in that instance, it was either the client post the bond, or we just asked the probate court to name you as the...
and what happened there? The client couldn't even be appointed as administrator because he wasn't from Ohio.
See?
He didn't even live in the state. Now,
that outcome could have been a lot differently had there been a will, right?
Had there been a will that named him, he would have been fine.
Okay. Well, if you have any questions while you're watching this, shoot us, just put it in the chat, okay? And send it to us. We'll do our best to answer those questions. If we're not able to answer it live or on this pre-recorded call, then we will answer it in your in-person meeting. If you have questions about your specific probate needs and you're not sure where to turn, I'm here to tell you that you've come to the right place. Our probate team can guide you through the process and help you take care of your loved one's estate. We understand the difficulties surrounded by the loss of a loved one, and we're here to ease the burden on you. We'll work with your executor. We'll work with your administrator. We'll work with your family to open up the estate and to transfer the assets with the least amount of burden on your loved ones. I can't even count the times that someone passes away and they come here because we worked with their loved one or because we agreed to help them out in their time of need, and they drop off a box of documents for us to go through. And you wouldn't believe how many times I've heard that Mr. Littlejohn, your team has done a great job. They've really eased the transition by handling this affair for us. So if you're looking for guidance and you're looking for somebody to help you navigate through the probate process, schedule an in-person meeting. We're here to help. Have a good day.